Item 4.
I'm suffering from a slight handicap with respect to item numbers 1, 2, and 4. These matters were not fixed today. They have suddenly come up. 1, 2, and 4. If I can pray for a little accommodation. 1 and 2 may be fixed on, my lord, 18th of June. And item number 4, we have agreed between ourselves, my lord, it may be fixed on 21st of July.
July.
Because there's a intervening vacation, and in between, my lord, our dates are not matching.
I put a substantial amount of time last night. Anyway, I have to accommodate, the learned AG.
Learned AG will treat you today.
Yes. He is my elder, so he will.
Learned, Mr. I Chaudhary, learned additional Advocate General. Advocate General. Submits that. In item 1 and 2, he has some personal difficulty today. Therefore, press for listing of these matters after.
It may be fixed on 18th of June.
On 18/06/2026. Praise the Lord, list after the on so and so 18. Then item 4, on the prayer of Mr. Chaudhary, learned Advocate General, and prayer not been objected to by Mr. Tititara, learned counsel for the petitioners. List this matter on
21st July.
21/07/2026.
Obliged. My lord, I seek kind indulgence to item 17, my lord. I could not lay my hands, my lord. So that item 4, there's some constitutional issue was there, so I was giving some time on this. My lord,
There's nothing.
next week, my lord. Next week. Next week, my lord.
Why next week?
Today, I'm also a bit handicapped to assist the court, my lord.
It's a cancellation of LPC.
I understand.
LPC.
I understand.
Very simple matter.
I understand, my lord. But I have not laid my hands on the brief, so I have to fairly make a concession, my lord, before the court, my lord.
Okay. On the prayer of Mr. Tititara, learned senior counsel for writ appellants, list this matter after 2 weeks.
1 week?
1 week or 2 weeks?
1 week is fine.
1 week.
Grateful.
My lords, if I may, my lords. My lords, I beg to mention item number 16, my lord, 16. My lord, I pray that this matter may be adjourned for today, my lord.
Why?
My lord, I need some time, my lord, in this matter, my lord.
As prayed for by, on the request of Mr. G. Talo, learned counsel for the appellate, list this matter after
2 weeks, my lord.
2 weeks.
Much obliged.
May I plead your lordship? My lord, I beg to mention item number 5, my lord. Here, my lord, our affidavit is ready, my lord. I will be filing within a week, my lord. So I need some more time. Yes, my lord.
Affidavit is required.
Yes, my lord. Here, my lord.
Dismiss.
No, yes, my lord.
Dismiss at the motion stage.
Yes, my lord.
Okay. Mr. MS T. Wang, this counsel submits that the affidavit in opposition is ready for filing. For listing of the matter after 2 weeks. Mr. President, list this matter after 2 weeks. List the writ appeal list after 2 weeks. In the meantime, the state response may file the counter affidavit.
Your Lordship, I beg to mention item number 14, Your Lordship. I'm for the informant in this case, Your Lordship. And the leading counsel, Your Lordship, is out of station, so the matter may be fixed after 2 weeks, Your Lordship.
Next week? After 2 weeks.
Okay. 2 weeks, Your
Lordship. 2
Lordship.
weeks.
2 weeks, Your Lordship.
You're Mr.
C. COVID, Your Lordship. I'm appearing on behalf of ex-Gyati.
Your name, please.
C. COVID, Your Lordship.
C. COVID.
Yes, Your Lordship.
COVID.
Yes, Your Lordship.
Don't scare us. Mr. C. COVID. K.
Yes, Your Lordship.
Make it K, huh? Don't make it C. K. COVID Learned Counsel appearing on behalf of Mr. X. Getty Learned Counsel for the respondent victim.
No, Your Lordship, informant, Your Lordship.
Informant submits that Mr. Getty has some personal difficulty today, therefore, praise for listing of the matter after 2 weeks. Praise the Lord, list after 2 weeks.
Much obliged.
At least we can take it.
Item number 3.
What to do?
I think.
My lord, in this PL, my lord, I believe, my lord, the petitioner should not have any more grievances against the state respondent, my lord. My lord, we have completed the whatever works left out, my lord. I think the learned council will agree with me, my lord.
Yes. Sir, may I apprise this court from the petitioner side? When it comes to all the state parties in this PIL, beginning from 1 to respondent number 9, even if they are discharged from this honorable court, we have no objections. During the pendency of this petition, all the grievances, that is the drainage system and the roads, have been beyond reasonable doubt completely mandated, sir. But today notice has to be issued for respondent number 10 to 15 as they have been successfully implemented as new respondents in this petition.
What is saying? What is saying? Please repeat.
Am I audible? Am I audible? Hello?
It's audible, but we're not clear.
Okay.
Please,
Sir,
please repeat.
Yeah. Sir, during the pendency of this petition, the grievances with which we have come up initially, all those grievances have been resolved, sir. That is, there were 2 issues, the potholes and drainage system, that has been completely responded and made clear by the state parties.
So we'll close the petition.
No, sir, not as a whole. Respondent number 1 to 9 are the state parties. All the state parties need not to be attached to this petition. They can be discharged. But respondent number 10 to 15 deals with the national highway. So they have come up with this petition for the first time, sir. Respondent number 10 to 15 are new implemented parties for highway.
It's okay. It's okay. Once your grievance has been redressed, what remains there?
Not grievance only regarding the state road, not the highway, sir. There were 2 roads concerned in this petition, state roads and the national highway. With regard to state road, all the roads have been completely developed and modified from the state parties. They may be discharged, sir. But respondent number 10 to 15 are yet to respond. So today notice has to be issued to respondent number 10 to 15 for filing their reply within this petition. They have been implemented, sir.
Just wait, sir. In which states of national highway?
Within the Likhavli town, sir.
So, are you sure it's not been road has not been constructed?
Yes, sir. No, not yet. Only the state roads have been completely done clearly, sir.
Whatever national highway?
No, sir. Nothing has been done. No, nothing has been done. In fact, the parties responsible for national highways have been implemented this petition now for the first time fresh. Hence, this amended petition was filed by bringing amendment in the cause title. Respondent number 10 to 15 are new parties. Before this petition came up today, sir, there was 1 whole year engaged for merely impleadment, which has been disposed of some times back from this honorable court. Hence, they were brought before this court in this petition by way of impleadment to respond. Respondent number 10 to 15 has to be issued notice, sir, for responding regarding national highway. 1 to 9 may be discharged.
We don't do it in a piecemeal. Yes. What to do?
Sir, if I may.
मिक्स confusion करा
Any lawyer pro Likabali?
Your Lordship is still confused whether National Highway. Anybody from Likhavali?
Sir, I myself is from Likavali, sir.
That's why we have a doubt on you.
Sir, I have some fair submissions.
Anyway, had Mr. Yes, is it not? By which order the 10 to 15 have been implemented?
Dated 26 March 2026 of the PIL only. It's in PIL, in this PIL file it reflects 26 March 2026.
Not Pierre.
26 March.
Have you filed the amended cost title?
Yes, sir. This petition is a compilation of cost title as well as the a few consequential amendments in the body of the petition. Those are the amendments, sir.
Okay. Heard Mr.
M. Longby.
M. Longby, learned counsel for the petitioners who submits that so far as the grievance against the state respondents, same has been redressed. Mr. However, since the grievance against the Union of India in respect of construction of National Highway at Likabali, same is yet to be same has not been same is yet to be redressed. Mr. The respondent number 10 to 15 have been implemented by an order dated 26/03/2026 in IA number 279 of 2025. Same notice is required to be issued. Accordingly, issue notice to the duly implemented respondent number 10 to 15.
Yes, sir.
10 to 15, returnable by 4 weeks. You take steps.
Yes, sir, definitely. Sir, my humble request, a fixed date may be given.
For the petitioners to take steps for service of notice upon the respondent number. The newly implemented respondent number 10 to 15. Within 2 working days, huh? Register post with, as well as by usual process. List on when?
Sir, any date as per the convenience of this court, sir, but one fixed date.
After 4 weeks, just give the date.
My Lord, as I have submitted, my Lord, there is no more grievance against the state government. So, my Lord, state respondent let me withdraw, my Lord, from these proceedings, my Lord.
You'll be there, we'll see what's there. Anyway, before that, you just write, since the grievance against the state respondents has already been redressed, the state respondents, the respondent states and its authorities which have been added in this petition stands struck off.
My lord, deeply obliged.
Sir, one fixed date may be allotted after 4 weeks.
23rd June.
Okay, thank you. Thank you so much.
Item number 6.
Caveat. Caveat.
Yes, Your
Quietas. Emtas. Emtas learned concept of the caveat. Caveat expenditures. Yes.
very limited grievance. What has happened is, although the matter has been remanded back to us, in a sense, for all practical purposes, what has been directed is that acquisition proceeding that was conducted in 2021. In essence, it has been directed that we take note of a notification, subsequent notification of 2022. But if your lordship will kindly come to the impute judgment, there are a few findings which create the problem. But if your lordship will kindly come to page 30, the impute.
Yes.
The problematic paragraphs are this, my lord. At page 38, para 7.
Yes.
Sri Ratan, learned additional AG, has also submitted that under section 26 of the Act of 2013, the collector is required to determine the market value. Since no materials were available at the time, the state government had relied upon a notification. At that time, the notification holding the field was this, 26/11/2011. He has, however, not disputed that the land was acquired in the year 2020. He has also submitted that in terms of the judgment of the Honorable Supreme Court dated 16/9, this is that main landing case. The state is willing to pay solatium and interest at the rate mentioned in the notification that it's so and so. So far as the payment of interest and solatium is concerned, this is the problematic part. This court is unable to accept the submission of the learned state council insofar as it relates to the notification dated so and so, in as much as after the enactment of the Act of 2013, it is the provisions of the said Act which will govern the bill. We are not disputing that this Act will govern. However, since market value is not available, we are guided by the notification of 2011, which had notified the rates. Now, if your lordship will kindly come to para 11. Section 20.
How you determine the market value? How you determine the market value?
There are notified rates, my lord. We fix the floor.
You have relied on the notification of 2011. How can you do that? If it's a market value,
there is no way of determining the market value.
You could have issued a notification when the acquisition is done in after 10 years, 9 years.
However, my lord, the problem that is created is
it defeats the the fragile the meaning of market value.
My lord, what has happened? We appreciate your lordship's anxiety. We are also not that rigid, but the problem is, acquisition proceeding took place in 21. How can we take note of something subsequent? What they relied on is this, my lord. If your lordship will kindly come to para 12, page 40. The determination of the rate of rupees 11 per square meter prima facie appears to be absolutely on the lower side and cannot be treated as fair.
And then if the entire matter is, rallied on the Mihin Laling, I think this court may not take up the matter.
Mihin Laling is the...
At least one of us.
That is something I had overlooked.
So it's rallied on Mihin Laling only.
Yes.
Is that it?
Yes. Mihin Laling is forms because Mihin Laling tariff
has clarified the law only, my lord. Not based on the only Mihin Laling, my lord. Now it's an, my lord, preemptive, my lord, intra-court appeal, my lord. By, my lord, stopping the, my lord, collector to exercise his, my lord, statutory duties, my lord.
No, in other words, it has clearly laid down provisions that should be applied for assessing fair compensation. Because, see, matter rallied on the Mihin Laling only, which this court, with the other side, when I was the other side.
Anyway, my lord,
paragraph 6.
after the decision of the Supreme Court, my lord.
Yes.
Paragraph 6 expressly
It
relies
arises
on.
out of that only.
Yes, my lord, it's absolutely my lord.
I think better I should not.
My lord.
In that case, my lord, may I pray, please? I'm coming back again on 2nd, my lord. Huh?
Sunday Monday pass question.
Sunday Monday yes. No, no.
No.
Rublu আছে।
I have to modify it.
Huh?
Modify it.
হয় নেকি?
তার next to করলে ভালো হবে।
তেতিয়াহ'লে 18th কৰিব লাগিব। তেতিয়াহ'লে 18th June।
Tell us any objection.
Well, because to my lord,
See,
because
if it
my
is-
lord has appeared as a counsel, my lord,
Huh.
in one of the proceedings before the single bench and the division bench, my lord.
Hmm.
Ultimately, it went to Supreme Court, my lord.
Huh.
And Supreme Court has decided, laid down the law, my lord.
Hmm.
So, my lord, I think
That is also against the, I mean, against
Yes.
the
Yes.
state of the state
my lord,
where I have appeared
my lord.
on behalf of the state.
On behalf of the state,
Paragraph
So this
6, in
paragraph
fact,
10, it's clearly says.
if your lordship kindly sees paragraph 6,
Hmm.
it is expressly relied on.
Hmm. I don't think it should take up,
my lord.
at least, me.
I otherwise don't have any objection, but
List this appeal before any other appropriate bench. Put out one of us. Huh? My name
may I just pray for a date, my lord? That way.
will be listed. You pursue. Ask your district
Man.
to get it listed.
Right.
Item number 7.
Item 7. Item 7.
Corresponding number 6, 7, 8, and 8,
Hmm.
my lord. I have instructed the appearance.
Hmm.
I pray some time, my lord.
Non appears for the petitioner on call. Mr. Arichnaba, learned additional advocate general for the state. Who else?
RWD is there, my lord.
G. Tarak, learned standing counsel for RWD are present. Next para. Mr. El Perme, learned counsel submits that. Learned counsel enters appearance on behalf of respondent number
6, 7, and 8, my lord.
6, 7, and 8, and prays for 3 weeks time to file affidavit in, file response. Praise the Lord. List the matter after
4 weeks, my lord.
4 weeks.
Four-
then.
four
4
weeks.
weeks, then 4. You have filed your affidavit.
Yes, my lord.
Okay. Next para. Office note dated 20/05/2026 indicates that affidavit regarding proof of justice service has not been filed. Mr. Howard. No. However, since the respondent number 6, 7, and 8 are represented by Mr. El Perme, the filing of affidavit as regards the proof of justice is dispensed with. This after 4 weeks. Huh?
Item number 8.
Need them to prepare the paper book.
Please, Your Lordship.
Paper book has to be prepared.
Yes.
Okay. Ms. MS N. Learned
Legal Aid Counsel.
Counsel for the appellant, as well as Mr. And MS TG Learned Additional PP for the state, as well as Mr. Techi Topu
For the respondent.
for respondent
Number
number 2. This is what POXO
No, 302.
30.
Murder.
Public. Respondent number 2. The trial court record is received. Registered to prepare the paper book. List the matter after preparation of paper book.
Oblige.
Item number 9.
What is to be reviewed?
My lord, this review isn't filed
Ah,
based on the, my lord, observation made by the Honorable Supreme Court, my lord.
where is the observation?
That is, my lord, page number 66, my lord.
66.
Connector C, my lord. Page number 66 to 67, my lord.
Yes. So you are ready that your review petition will be dismissed.
No, my lord, since,
So that you can file SLP
my lord, actually,
against the main order and review order.
no, my lord, this was the observation made by the Honorable Supreme Court, my lord, which
Liberty
opined that,
for.
just opined that, my lord, the review has to be filed.
It's okay.
Yes.
Last para 4. This president reserving liberty as spread for and if so advised permissible to file special appeal against the main order as well as the review order. So when you have not taken the ground, the first submission made by the is completely different from submission made before the High Court. In this view of matter, received for putting the approach the High Court for filing the review. Have you taken this ground?
Yes, my lord, that ground we have taken, my lord. So that's why we are filing this review petition. My lord.
So we have not considered that.
Yes, that is, my lord, our submission, my lord.
We have not considered that.
My lord, that ground we have taken. My lord has also perused that very ground. That our ground
Where
was
is the impute order?
impugn order is, my lord, page number 38 to 65, my lord.
Where it is? Any discussion has been made? Page
number 38 to 65, my lord. Page number 38.
68.
My lord, 38.
No, where is this Any discussion on this?
My lord, if I beg to refer, para number 14, ma'am, 64, page number 64, ma'am. In the present case, my lord, para 40, ma'am.
40.
Yes, sir, 40, ma'am. In the present case, may I read, my lord? In the present case, as noted herein above, the justified rate were prepared based on the market value of each item in respect of Chatham CD block by the appellant authorities and were approved on so and so, fixing the justified amount at rupees so and so, and so and so, equivalent to percentage of minus 7.31 of tender amount value of rupees so and so. So the bid of petitioner, respondent number 1, writ petitioner, respondent number 1 and 5 was found to be minus 10 of the justified rate, whereas the bid of appellant respondent number 2 was exactly minus 7.31, my lord. So, my lord, our case was, my lord, our variation was within 5%, my lord, within 5% permissible review, which is as governed by the CPW, the manual, my lord, clause 24.3.2, my lord. But my lord has opined that our is within falls under minus 10, minus 10% of the.
It's as per the record only. Is it not 10, minus 10 point?
No, madam. That was not our case, madam.
It's not your question of your case. It's as per the record. Your bid was minus 10%.
My lord, if that
may not be, maybe within the 5% variation of 5%, but then this your bid was minus 10%.
No, my lord. Our bid was, my lord, within 5% variation, my lord.
Let us see.
That is
from what you are saying.
Para 43, man. For para 43.
43?
Para page number 43, man. 43. 43, man. 43. Para 7, my lord. Before the single judge, the writ petitioner respondent number 1 to 5 had contended that the approved rate that the offense was actuated by the political and external consideration, and that its bid was within the permissible variation under the CPW works manual, the deviation being only 2.9% below the justified rate, my lord. And my lord, record is also there, my lord. And page number 48 also, man. Page number 48.
You read para 8 also.
The respondent authorities, on the other hand, contended that the justified rate had been fixed at minus 7.3 of the estimated cost. Estimated cost. My lord, estimated cost is different, my lord, and justified rate is different, my lord. Our case is, my lord, our rate, the bid amount is minus 2.9 of the justified rate, my lord, not from the estimated cost, my lord. Here it speaks about justified rate, my lord, just justified cost. Contended that the justified rate has been fixed at minus 7.31% of the estimated cost, whereas the bid amount of a writ petitioner was minus 10 below the estimated cost and was therefore unworkable. It was contended that the concept of the justified rate was introduced precisely to prevent
See, it has to be the variation has to be read with the justified, the rates also.
My lord, as per records, my lord, meantime, at the time of hearing, we can also demonstrate before my lord, that our rate, the paid amount which I quoted is within the 5% variation of the justified rate, my lord. That is minus 2.97, my lord. That is our condition, my lord.
Minus?
Minus 2.9, my lord.
It was within the permissible variation.
Yes.
Permissible variation, but then your deviation being 2.9% below the what about minus 10% below the estimated cost?
That is estimated cost is, my lord, different, my lord.
It is different, but then the basis of award, because your is the below minus 10% below the estimated cost, right?
My lord.
So therefore, it's not workable.
But my lord, CPWD closed.
What does it say? Why the CPWD says that just because you are within the variation of 5%, you should be allotted the work?
Justified rate. It's speaking about variation, 5% variation within the justified rate. My lord.
Then what about
Justified.
the appellant or the respondent? What was this justified?
The respondent has quoted exactly the justified rate, my lord. Exactly the justified rate.
Then what is the
that is minus 7.31 of the estimate.
Then what is the whether it falls under the variation of 5%?
Yes, man. There's also falls under the within variation.
Yours also falls under 5%. Then,
my lord, because we are L1. Because my lord,
workability has to be seen. Suppose both the bidders is within permissible limit, variation of 5%. What would be the next steps to be considered?
Because my lord, our
he also, I mean, the appellant also falls within the variation of 5%.
My lord.
It's not that his case is not within the 5%. Is not it?
My lord.
The next would be what?
Because my
suppose if they both of you falls under the variation of 5%. It's not that his case, the appellant was not, the bid doesn't fall within the variation of 5%. Right?
My lord.
Is it your case?
No, my lord.
Just because
My
it's your bid falls within the 5%, a variation of 5%, it doesn't mean that you'll be awarded. What we have said is, what we have found is that we're not concerned about, since it is not required to be considered because both the bids is within the permissible 5% permissible limit, right? A variation, sorry. 5% variation. There's no dispute. Then what next to be considered is what? The workability. And they have fixed the justified rate. Justified rate. Justified rate. Is that it?
My lord.
Is it the case that if a bidder falls within the 5% variation, he should be awarded the work, irrespective of, I mean, without ignoring the justified rate?
Well, our case is, my lord, that we are the L1 and we falls within the justified rate, my lord. 5% variation within the justified rate, my lord.
What about them?
My lord, as for their condition of contract, their my lord, special condition, my lord. It is clearly stipulated that, my lord, 5% variation, those who put L1, those who is L1 within 5% variation, that what should be awarded to the bidder, my lord, particular bidder, my lord. So that was our contention. We are within the 5% variation of the justified rate, my lord, which is permissible within the CPWD rules, my lord. So, and we are L1, my lord. So that was our case, my lord.
See, L1 doesn't mean that you will be given the work. Normally, L1 should be given, right? But why justified rate is prepared? To see the workability. I think it's not a case of review. You need to go to Supreme Court again.
My lord, at this stage, my lord, this matter comes up for the first time. So,
then why we're taking so much of time?
Next, it may be fixed for the matter, hearing, my lord.
My lord,
You are
Otherwise,
wasting your time. We'll
My
discuss
lord was-
it. There's no
my lord-
ground for review.
My lord,
Go back to, I mean, you approach the Supreme Court again.
Otherwise, all these issues, my lord, it was taken, my lord, and your lordship has considered those issues also.
Then why this, there's a order of the Supreme Court.
No, that I've also seen, my lord. And another aspect is, my lord, that their writ petition, my lord, has seen that the prayer is for the setting aside of that recommendation as well as for the writ of mandamus for
Okay.
awarding the.
Doesn't want to argue the matter today.
Now, my lord, just the that subsequent development, my lord, the work has already been completed, my lord, since it was for supply of materials, my lord.
The problem is Supreme Court has given them a liberty to file, not only file a liberty, reserving the liberty to file the approach by SLP against the main order as well as review order. That is your prayer before the Honorable Supreme Court. So you are sure that the review petition will be dismissed.
my lord, that is because they have
And
given.
technically, if you go, there's no case for review. Anyway, if a work is completed, nothing remains.
Completed, my lord. This is now only
And
academic
he is not
exercise.
insisting for disposal.
Proceed.
Anyway, had Mr. El Kurdu, learned counsel for the review petitioner, issue notice. Notice has been issued, no.
No, no.
Issue notice returnable by 4 weeks. As Mr. Who is one?
1 to 4.
Mr.
1 to
B. Pitcher, Learned Standing Council, RD, sorry, RD, and Mr. Disoki,
And for
Council
5.
for Respondent 5, enters appearance and accepts notice on behalf of all the respondent. Issuance of formal notice, service of formal notice is dispensed with. When?
My lord, 3 weeks, after 3 weeks, my lord.
We'll make it 4 weeks. 4 weeks.
My lord, 3 weeks,
It has to be, both of us should be there.
my lord.
Otherwise, it's not no, even if you say 2 weeks, 3 weeks, no. 4 weeks, we'll make it 4 weeks.
Obliged.
Item number 10.
Yes. Anti-corruption. Speed posting and concern. Usually with non appears for the petitioner. On call. MS next para. P. Pang Learned State Council. Appearing for all.
Yes, sir. 1 to 8, Your Lordship.
Respondent 1 to 4 is present. Office note dated 20/05/2026 reflects that the notice issued through a speed post in respect of respondent number 9 is returned unserved, and the notice issued through usual process is still awaited. Next paragraph, consider above. Learned counsel for the petitioners to take precise steps for service of notice upon respondent number 9. Within a week, list after 4 weeks.
Obliged, Your Lordship.
Item number 11.
Heard MS so and so learned counsel for the petition appellant and Mr. Deloy learned public prosecutor for the state. Await service report in respect of respondent number 2. List after 3 weeks.
Deplorable.
Item number 12.
My lords, by order dated 9th of February, my lord, we were directed to file an amendment petition, my lord, which we have done. And thereafter, my lord, because there was a problem with the address of the respondent number 5. And now we have taken a corrective measures, my lord. And today is for consideration to directing steps upon the respondent number 5. So may I pray, my lord, notice may be issued to respondent number 5. We'll take steps accordingly, my lord.
In IA?
My lord, in IA, my lord. These are condonation applications, my lord.
Notice has been issued to respondent number 5 only?
5 only, my lord. The others have
heard Mr.
P. Yobin.
Then counsel for the applicant. Next para. Issue notice to the respondent number 5.
Yes, my lord.
Returnable by 4 weeks. Then counsel for the petitioners to take steps for service of notice upon respondent 5. Barrister. For 1, 2, and 3. And MS?
And Lordship, I'm for respondent number 4, Lordship. On behalf of MK. Yes, Lordship.
For appearing for respondent number for Mr. M. Katolan DSGI are present. You have any objection to file? You will not file any objection.
No, Your Lordship.
Delay of 42 days.
42 days, my lord.
Oblige, Your Lordship.
It is after.
Much.
Item number 13.
What is this IA?
My lords, this IA has been filed for impleadment of the Union of India as respondent number 17, my lord. 117, my lord.
Why they record?
Pardon, my lord.
Why the Union of India?
My lord, in the main petition, inadvertently, the respondent number 16, therein, the Union of India was made a party. However, both the BRO and the Union of India were clubbed together, my lord. So we had made a prayer that we may be allowed to make the Union of India as a separate respondent, my lord. And our prayer was allowed on the last date, my lord. Our prayer was allowed by order dated 12th May, my lord. So we are making this, we have filed this IA for impleadment of respondent number 17, my lord.
Mr. G. Talo, learned counsel for the applicant, and also had who else are there?
Yes.
Mr. Estafit, and also had Mr. Estafit, the senior government advocate for respondent number 1, 2, 3, 4. 1, 2.
Yeah.
1 to 13.
1 to 13.
And Mr. Comma Mr. And Mr. Opa, the special PP for SCB for respondent number 14 and 15, 14 and 15, as well as MS Waiga, learned counsel for appearing for Mr. M. Katolan DSGI for respondent number 16. Next para. This is an application praying for impleadment of the Union of India, represented by the Secretary, Ministry of Defense, within bracket Border Roads Division, bracket close to New Delhi, as party respondents in the connected PL number 07 of 2026. Next para. What is the grievance in this?
PIL, my lord. My lord, basically, the grievance herein is that, my lord, that's certain individuals, my lord. They have been given compensation. Some have been given inflated compensation. Some have been given compensation for non-existing structures. We are not against
In
that.
respect of which?
My lord, it is construction improvement of Dite Dime Miging Road from existing
Just wait.
that Siang district.
You have not said anything in your IA. At least you could have made.
Yes, my lord. Apologies, my lord. We have only given the bare details, my lord.
The petitioner by way of public interest litigation, the applicants by way of public interest litigation has approached this court against the payment of compensation, alleging payment of compensation in respect of construction of
Construction improvement of
compensation of land for construction of
this Dite Dime Miging Road
Miging road
in Siang district, my lord.
in Siang district, alleging what you have alleged?
That, my lord, the
inflated compensation payment of inflated rate of compensation to the persons having no land.
No land, and some people's land have been their value have been inflated, my lord.
Inflated rate of compensation to the landowners and payment of compensation to persons having no land. List the road in question is constructed by
a BRO, my
by the Border Road Organization. Respond number 16.
16, my lord.
Under the Union of India Ministry of Defense within bracket Border Roads Division bracket close. List. Next para. Having considered that the issue raised in the connected PI is against not only the state of Arunachal Pradesh and in authorities, but also the Union of India, particularly the Ministry of Defense, then bracket Border Roads Division, bracket close. And also considering that this court, by an order dated
12 May.
12
May
05 2025 26
May
26 has allowed the petitioners to file the appropriate application for impleadment of the Union of India, we deem it appropriate to allow the present interlocutory application as the Union of India represented by the Secretary, Ministry of Defense within bracket Border Roads Division, would be a necessary party for proper adjudication of the connected PN. Accordingly, the petitioner is allowed to implead the Union of India so-and-so secretary, represented by so-and-so, as party respondent number 17 in the connected PL. Appropriate connected PL. Next para. IA instance allowed and disposed of. In PL is not listed. It's listed.
It listed.
And PL 7, in view of the order passed in IS so and so, then counsel for the petitioners to file amended cost title list, amended cost title list, registry to incorporate the on receipt of the amended cost title, the registry to incorporate the newly implemented respondent number 17 in the PL. That's all.
That's all. My lord, there is a small prayer, my lord. My lord, by the last order, we were directed to take steps upon number 5, 6, 7, and 10. So, my lord, we are praying that after the amendment, we may be allowed to take steps upon them, my lord. Amendment of the
Petitioners to take steps for respondent number
5, 6, 7, and 10.
5, 6, 7, and 10 after filing of the amended cost title.
Much amazing.
Item number 15.
Yes. Continue. Yes.
May I, Your Lordship? Lordship, I'm appearing for the appellant, Your Lordship. Here in this case, Your Lordship, the learned trial court convicted the appellant strictly based on retracted confession, Your Lordship. Your Lordship, being aggrieved and will serve cause of justice in default of payment of fines, the convict is to undergo for the simple imprisonment of 3 months.
It's okay.
Lordship.
Yes.
So, Your Lordship, the case of the prosecution is that, Your Lordship, on 1/11/2021, Your Lordship, in the midnight, the appellant had surrendered before the Napra police stations and disclosed that he had cut his mother with dao and set the house on fire. And thereafter, OCPS Napra detained the accused on police stations and verified the incident and visited the PO.
Okay.
Your Lordship. Your Lordship, the FIR, Your Lordship.
Yes.
FIR is page number, Your Lordship, 1, Your Lordship. To the officer in charge, Police Station Napra, District West Coming. Complaint against one Sri Johnny Chungruju under section 302. Sir, with reference to the subject cited above, I would like to inform you that on 2/11/2021, 12:30 last night, one Sri Johnny Chungruju, son of late Jesu Chungruju, has burned down to his mother at last night without any reason. In this regard, I would like to request you to kindly action under section 302, Your Lordship. So after the FIR on 2/11/2021, Your Lordship, the formal FIR was registered, Your Lordship. The prosecution have examined altogether 9 prosecution witnesses, Your Lordship. The witness, Your Lordship, witnesses number, admittedly no eyewitnesses to the incident in questions, and entire case is based on retracted confession, Your Lordship. PW1 to PW4 is hearsay witnesses, Your Lordship. Your Lordship will see PW5, who is the younger brother of the accused and son of the deceased. That is PW5, Your Lordship. Your Lordship may see the deposition, Your Lordship. PW5, Your Lordship.
So 1 to 4 is not
1 to 4 is not relevant because they are hearsay witnesses and no relevance, Your Lordship. That is at page number 42, Your Lordship, paper book.
42.
Yes, Your Lordship. PW5, Your Lordship. May I, Your Lordship? On oath, I'm appearing in this case as a witness. Accused is my elder brother and used to stay at Upper Jang with mother and his daughter. I used to stay at Bajar in separate house. I do not remember the date, but it was October-November 2021. I got a mobile call from PW4 at around 12 midnight, intimating that our house was burning in fire. I reached to the PO within half an hour, and house was already burned down. Still, fire was burning. I dosed the fire. In the meantime, police personnel arrived at PO. Police told me that the accused has already deposed before them that he set the fire, and I was instructed not to tamper the evidence of gutted house. I was also told that on next morning, the police will come to see the dead body of my mother. Accordingly, I restrained myself to do any kind of those activities in the burnt house. On next morning, the police arrived and the dead body of my mother was recovered from burnt house in my presence. The 80% of body was already burnt and only 20% was left. I identified body of my mother. The accused has surrendered himself before police. The dog was recovered in my presence. Paper exhibit so-and-so is my signature so-and-so, so-and-so. And in cross, Your Lordship. It is not a fact that in this case, I do not believe that it is a case of accident, as the accused has admitted to commit the offense. It is a fact that I did not witness the accused disclosing the commission of offense before police. It is not a fact that police have wrongly implicated the accused in this case. So PW5, Your Lordship, is the complainant. And PW6 is a minor daughter, Your Lordship. Next page 43. She does not know, Your Lordship. I'm appearing in this case as a witness. At the time of incident, I went to watch TV in other house. My grandmother was at house when I left the house to watch TV. When the fire engulfed my house, I was in the other house. I did not know how the house was set into fire. I do not know how my grandmother died. I do not know how the accused father after the accident. The man standing on the dock is my father. Cross was declined, Your Lordship. Now PW7, Your Lordship. PW7 was declared hostile, Your Lordship. Now, Your Lordship, may turn to page number 45. PW8, who is the IO, Your Lordship? IO of the case, Your Lordship. May I, Your Lordship? On 1/11/2021, I was posted at NAPRA PS case, NAPRA PS as OC. On that day, around 12 o'clock, Your Lordship may mark the timing, 12 o'clock in the night, accused Dongso Chungruju appeared at PS and surrendered, stating that he has killed his own mother, Srimati Sangjo Songroju alias Perde Chongrujo, aged about 60 years, with a dao on the right thigh and set fire his own house. I detained accused Dongso Chongruju for interrogations and investigation. On 2/11/2021 at about 8:30 a.m., on written complaint received from Sri Medi Chongruju, it is alleged that on dated 2/11/2021 at 12:30 noon, Sri Johnny Chongruju Dongso has burned down his mother on 1/11/2011. On receipt of complaint, NAPRA PS case number 6/21 under section 302/436, IPC was registered by the OCPS NAPRA and undertook investigation. During investigation, I have visited PO and found that the house of the accused Dongso Chungruju was burned to ashes during examination. I have learned that his mother was also staying in the house and was missing. We could not trace her as it was night. On the next day, I revisited PO. During search, found a dead body, which was totally burnt, who was later identified as Srimati Songjo Chongruju alias Perne Chongruju by her son, Sri Medi Chongruju. During search, a local dao without handle was recovered and seized on being identified by Medi Chongruju, PW5, who is the complainant in Your Lordship, identified by the Medi Chongruju as the weapon of offense. The dead body was forwarded to General Hospital for PME after conducting inquest. On 2/11/2021, accused Dongso Chongruju alias Johnny Chongruju was arrested for interrogations and forwarded to this court with a prayer to remand accused person in judicial custody. During investigation, I have examined available witnesses and recorded their statement. I have forwarded accused to learned CGM SEPA for recording of confessional statement under section 164. I have received PME report and confessional statement of accused. I have drawn rough sketch map of PO and taken photographs. On completion of investigation, I have found prima facie case under section 302, 436 IPC is well established against the accused Dongso Chungruju. Accordingly, I laid charge sheet. Accused standing on the dock is identified by me. During investigation, it is revealed that the alleged accused had twice attacked his mother and set the house on fire because he had illicit relationship with Daimu Jungluju, for which his mother was reluctant. Meanwhile, he cut his mother and later rushed to PS for surrender. So this Daimu Jungluju was never examined, Your Lordship. And the paper exhibit 1, so and so, in cross, Your Lordship, page number 47, Your Lordship. It is not a fact that I have not prepared disclosure memo of accused person. It is a fact that there are no eyewitnesses who have seen accused assaulting his mother with dough and setting fire in the house. I do not know if Daimu Jungluju has denied any illicit relationship with accused. It is not a fact that house gutted due to accidental fire. As the house is totally burned, nothing except the burned dead body and the dough without handle could be recovered. Accused has disclosed before me and the learned CGM regarding killing of his mother. So, Your Lordship, IO had mentioned the timing 2 o'clock, 12 o'clock, Your Lordship. So, Your Lordship may kindly see the confessional statement, Your Lordship, for a moment. Confessional statement is at page number 17, Your Lordship.
17.
Yes, Your Lordship. Starting from page number 17. The next page, Your Lordship, page number 18, the operative portion, Your Lordship. Serial number E, Your Lordship. For how many hours you were with the police and whether the police threatened or applied force upon you? Answer: I exactly do not know how long I was with the police. On 1/11/2021, immediately after the incident, I went to the police station, Napra, and surrendered myself at around 10 p.m. So there is a inconsistency, Your Lordship. He says at 10 p.m. or so. Thereafter, at 2 a.m. or so, I was taken to Bomdila jail. And the statement is at page number 20, Your Lordship. Page number 20, confessional statement, which was later retracted, Your Lordship. May I, Your Lordship? Name of the accused, Dongso Chungruju, aged about 39, father's name late so-and-so, resident of so-and-so, so-and-so. My name is Dongso Chungruju. My permanent address is upper so-and-so, so-and-so, so-and-so. I have a 10-year-old daughter, namely Miss Jyoti Chungruju. My wife eloped with a Nepali man 3 to 4 years back, and thereafter I never remarried. I live with my mother and daughter in the village for the last 2 to 3 months prior to the present incident.
Yes, sir.
I beg to mention item number 8. Because that Mihin Laling principle will be applicable, Malat. So,
item.
yes.
Item 8.
On 3rd June.
Okay. List before, we'll say list before any other appropriate matter.
Fix that.
You make a mention to the registry.
And Malat, this writ petition number 613 has been, notice was issued in December 2025. The case has not been listed till date.
Monday?
Maybe
tomorrow.
Tomorrow? It's just for whether to see what.
Monday for orders.
Only for orders. Tomorrow.
Not tomorrow then. Orders.
When, Lordship?
For orders.
For orders tomorrow.
Tomorrow.
Okay.
May I, Your Lordship?
Yes.
Your Lordship, with the consent of the other party, I beg to mention item number 6. The conducting counsel is out of station due to some urgent matter. So kindly adjourn the matter today.
What is the matter about?
Pardon, Your Lordship.
What is the matter about?
Compensation, Your Lordship.
Okay. On the prayer of MS?
Tojum Tao.
T-Bum.
Tao.
Tam.
TAO, Tao.
Oh, T Tao Learned Counsel. Appearing on, you are not there?
No, Your
Appearing on behalf of Mr. K. Learned Counsel for the petitioners. List this matter after?
On 26.
After 2 weeks, after a week.
My lord, there is an interim, so can it be on 26?
Why 26?
26, otherwise the matter has become infructuous. The matter has been referred to the authority. Reference had been now, but there is an observation.
Against the reduction of the
compensation.
Compensation.
Yes.
Okay. And 26 in that case. On 26.
Your Lordship.
Yes.
Victim mentioned section number 4.
Lordship,
I'm appearing on behalf of standing counsel, Mr. P. Taba. Lordship, we need some more time to file our affidavit in opposition.
Rural Bank.
Yes.
The claim is based on the High Court judgment. High Court of Delhi or Supreme Court?
Yes, Supreme Court, Your Lordship.
Supreme Court.
Yes.
Anyway, objection no.
No, Your Lordship. So, but Your Lordship, they may file
MS
as early as possible.
MS
W. General.
W. Jena, Learned Counsel, appearing on Mr. T. Taba, Learned Standing Counsel, Rural Bank, come up for the respondents. Submits that Mr. Praise for listing of the matter after 3 weeks.
3 weeks, Your Lordship.
3 weeks. So as to enable the respondents to file the counter affidavit, placed of her. We are not being objected to by Mr. M. Tasso, Learned Counsel for the President. Let this matter be listed after 3 weeks. List the respondents to file their response on or before the next date.
Obliged.
Well, my lord.
Yes.
My lord, in item number 3, my lord, I am for the petitioner. I may be allowed to withdraw the matter, my lord. This matter has become in practice, my lord.
Item 3.
Yes, my lord.
Okay. You have sought for only accommodation till academic year 2025 to 26.
Yes.
It's over now.
Yes.
That has been done.
Yes. Did you help her out? Did you consider?
My lord, that part, my lord, I have
Anyway,
communicated to the department.
Mr.
NUB, my lord. YUBI.
NUB, Learned Counsel for petition submits that the writ petition has become in process. Next, Mr. T. Tagum, Standing Counsel, Education Department is present. According to the writ petition stands closed on, having been become in process.
Right, my lord.
Always allowed to mention item number 9. Seek for an adjournment.
This is listed for orders. We'll see what orders to be passed. Have you filed the affidavit?
Yes, I think.
We'll see. You be there. This listed for orders. We'll see.
Yeah. Allowed to mention item number 10 and 11. Also.
10 and 11.
Yeah.
This is also 10
No.
and 11. We'll see.
Withdraw. I would like to withdraw the.
10 and 11.
Yes.
Why?
As the petitioner is no longer interested.
You have instruction to withdraw.
Yes, sir.
Then Mr.
Jet Mandau.
Your name is not there.
Yes, I am appearing on behalf of K. Taja.
Appearing on behalf of Mr. K. Taja, Learned Counsel for the petitioners, submits that he has an instruction to withdraw this petition. List of
11 both.
Ms. T. Wang Matlan, State Council is present. Accordingly, the petition stands closed on withdrawal. Same order. Item 11. Same order.
10 and 11.
Same order, separate, but separate. We'll resume at 2 with full stomach, full belly.
Item number 1.
Yes.
One of the petitioners before your lordship are 4 superintending engineers of Rural Works Department. They are agreed by the action of the government in constituting a committee for processing tender matters by taking away their power, which is there under the PMJSY scheme of the Government of India. That is the grievance. Lordship, may I kindly turn to page 24, my lord.
24.
My lord.
Guideline.
My lord. It starts from, I'm sorry, my lord, it starts from page 22 actually. That is relevant, my lord. If the lordship kindly comes to page 22.
22.
My lord. This is the guidelines of 7th of May 2013. Guidelines for evaluation of bids and award of contract under the Pradhan Mantri Gram Sadak Yojana. Please refer to so lordship. Straight we go to the 4th, 5th line from top. In between, my lord, states were asked, lordship, seen, my lord, states were asked to furnish their comments. And after consideration of these comments, guidelines for evaluation of bids and award of contract under Pradhan Mantri Gram Sadak Yojana PMGSY have been finalized and are attached herewith. These guidelines also include process for dealing with single bids, tenders, etc. Now, lordship will kindly see what is the guideline. It starts from page 24, my lord. And the relevant portion is at page 26.
Yes.
Page 26 at the bottom, lordship, kindly see 5.1. Authorities in bidding and contract management. The State Rural Works Development Agency, SRRDA, shall be responsible for inviting bids, evaluation and approval. As such, the employer shall be the SRRDA, the head of the district program implementing unit DIPU, not below the rank of executive engineer, shall be responsible for contract management. As such, the engineer shall be the head of DPIU. If you lordship kindly turn to the next page, my lord. 5.3. 5.3 says opening of technical bids and evaluation. Technical bids shall be opened by the designated authority using designated digital signature certificates as prescribed under the so-and-so. The technical evaluation shall generally be started immediately after the opening of the technical bids. Technical evaluation of the bids shall be carried out by the committee, lordship kindly, this is important, committee constituted by the concerned SRRDA, which shall comprise of the following: head of PIU or superintending engineer having relevant jurisdiction. And then B, one other head of PIU, superintending engineer nominated by the SRRDA. And third is finance office.
Head of PIU?
Head of PIU, my lord, is the program implementing unit.
This is not the rank of executive engineer.
Yes.
Okay.
Now,
it will be either the head of the PIU or superintendent engineer.
Yes, and of the most important is of the relevant jurisdiction, my lord, of that particular jurisdiction. And then there are 2 other members. Now, if your lordship kindly turns to next page 28, 5.7 about the opening of financial bid. Down below 5.7, 5.7, it says opening of financial bid. Here also similar, my lord. Accordingly, the financial bids will be evaluated by the following committee constituted by the SRRDA, Chief Executive Officer, SRRDA, Chairman, Engineering Chief or Chief Engineer having relevant jurisdiction. So the constitution also has to be done by the concerned SRRDA and the persons mentioned head of PIU or superintending engineer. Now, what has happened in our case, my lord, page 31 is the first order issued by them.
This is for opening 5-7 Chief Executive Officer.
My lord.
Engineer in chief is what?
Chief Executive Officer of SRRDA. Well, SRRDA, as I have mentioned, my lord, it has been defined at page 26, State Rural Roads Development Agency at page 26, what we have seen, my lord. So that SRRDA will do everything, and the relevant executive engineer or superintendent engineer of the relevant jurisdiction will be the chairman. Now, what has happened in our case, my lord, page 31 is the first order issued by the...
No, this page 28.
Yes, my lord.
Opening of financial bid is by the Chief Executive Officer, SRDA.
Yes, my lord.
And Chief Engineer, there is no Superintendent Engineer.
Yes. Chief Engineer, Executive Engineer in Chief or Chief Engineer having relevant jurisdiction, so far as financial bid is concerned. We have no difficulty with that, my lord. Then comes the first order, impugn order at page 31. It's an order of 25th August 2024 to effectively implement and monitor the bridge construction under various programs across the state. A bridge wing is hereby constituted with the following officers, namely Sri So, Superintendent Engineer and Nodal Officer Head. Then other members are there, EE, etc. So for the entire state, any bridge construction under the Rural Works Department, my lord, and for PMGSY and for VVP, that is the Vibrant Village Program, it has been concentrated in the hand of one and taking away the power of all other superintendent engineers of the circles. Now, although they issued this, they did not actually implement it. And we have got, just now today, we have got one minutes of 19th of December 2024, after this date, my lord, where the superintendent engineer functioned. Jurisdiction superintendent engineer has exercised his power and the government did not enforce it. That is why we did not challenge also. Thereafter, my lord, recently, next page, page 32. On 23rd of April 2026, page 32, my lord, they have now made certain more things. In pursuance of NRRDA guidelines for evaluation of bids and award of contract by NRRDA circular number so that circular I first read, PMGSY of the Government of India, 7th May 2013. Standing committees has been reconstituted for opening of technical and financial bids and evaluation of long-span bridges under PMGSY and Vibrant Village Program. Now, Lordship will find committee for opening technical bids and its evaluation. Superintendent Engineer, Nodal Officer, Bridge Wing Headquarter, Chairman, then Superintendent Engineer, RWC, respective circles, they are members. So, the Superintendent Engineer of the respective circles becomes only a member and they have got no authority. It's the Chairman who will do everything because he is on the top and thereby taking away the power of all Superintendent Engineers of the respective jurisdictions and circles. Thereafter, they have made some more modification, page 33. Here, only one modification they have made of that under serial number A, Committee for Opening of Technical Bids and Evaluations. SC Nodal Officer so remains chairman and Superintendent Engineer, RWC, respective circles have been brought only as a member secretary. So the grievance of the petitioner is that by doing this, first of all, they have violated the PMGSY guidelines, which clearly says that constitution has to be done by this SRRDA, and it is the jurisdictional superintendent engineer or executive engineer PIU. One person cannot be the chairman of the entire states. In that case, when all the superintendent engineers of all other circles will be denuded of their power.
But you are a member secretary.
Member secretary, but membership secretary has got nothing except for writing letters, etc. But the entire power has been concentrated in one hand, deliberately. Whether that can be done under the PMGSY, it's very important. And the Government of India has framed deliberately a particular guidelines. And it was also said that how the tender is to be processed. Who will be the authority specifically? And it is the constitution also has to be done by the SRRDA. By violating all norms and the guidelines, they have first constituted a breach wing. They did not implement it. Now they have reconstituted a standing committee in place of breach wing.
So breach wing is what?
Well, page 31.
You are also challenging this?
Yes, madam, I'm challenging this also.
Yes.
My lord, there is no any illegal since only for long span bridge only. It needs some technical aspect, some more technical things. So only for long span bridge order.
Is it against the guideline?
No, I don't think it's against the guidelines. The guideline does not say that only in the some civil works.
So why this man only?
No,
why this SE only? Other OCs are incompetent or what?
No, they all the respective circle AC they are made the member secretaries.
It's all right. How can they are in the same rank?
Of course, they are in the same rank, but
You make the
AC headquarters.
chief engineer. You make the chief engineer.
This is only for long span bridge.
Doesn't matter. First, you have constituted the bridge wing.
Yes.
Across the bridge wing, you have.
Then a standing committee.
Standing committee.
Purpose is
all along this man only.
He maybe have a technical sound in this bridge regarding.
Say that.
Yes.
Are these? That's why I'm asking. Are these SEs are incompetent? They don't know anything.
No, that they have to. That will be reply. We need to file then affidavits. And today let notice we goes, my lord. Notice we issue.
Okay. Heard Mr. D. Majumdar, learned senior counsel assisted by Mr. Tijamo, learned counsel for the petitioners. Challenge made in this writ petition is to the orders dated 25/08/2024, the order dated 25/08/2024, office memorandum dated 23/04/2026 and 23/04. This is not same.
My lord, late it's same, but then difference is there, my lord. Now he has been made, the chief superintendent engineer has been made member secretary.
Office memorandums dated 23/04/2026. Whereby the respondent authorities, the secretary within bracket RWD, Government of Arunachal Pradesh, and CEO ARDDA, and Secretary RWD and CEO ARDDA, Government of Arunachal Pradesh, has constituted bridge wing in the department and subsequently constitute a committee for opening of technical bids, technical and financial bids, and its evaluation. Conferring, and by appointing.
Constituting a committee.
No, by that constituting committee that we have said. By appointing the respondent.
My lord.
Who is the respondent here?
Yes, my lord.
Respondent number
3, my lord.
Respondent number 3, namely Toko to superintending engineer, RWD. as the chairman of the wing, bridge wing. Then no, nodal officer head as nodal officer of the officer within bracket head of the bridge wing and other DPIU and other engineers, huh? And one executive engineer, 4 junior engineers as the members of the bridge wing, huh? And also constituted the committee headed by the respondent number 3, a chairman and members and the superintendent engineer RWC within the respective circles as member and member secretary. List of next para. It is the contention of the petitioners that as per the guidelines for evaluation of bids and award of contract under the Pradhan Mantri Gram Sadak Yojana as circulated by 07/05/2013, the State Rural Roads Development Agency shall be responsible for inviting bids, evaluation and approval. For which the committee shall be consist of head of PIU or superintendent engineer having relevant jurisdiction as chairman, along with one head of the DPU, superintendent engineer, nominated by SRRDA, and finance officer, division and accounts officer of PIU, nominated by the SRRDA, and the opening of financial bid and evaluation shall be consist of the chief executive officer SRRDA as a chairman, chief engineer in chief or executive engineer having relevant jurisdiction, and a financial controller as a members. You take it from page 27 and 28, huh? It is further submitted that therefore the petitioners who are also serving as superintending engineer in different circles. Different circles has been made as a member secretary under the respondent number 3, who is also a superintendent engineer, in violation of the guidelines. Guidelines for evaluation of bids and award of contract under Pradhan Mantri Gram Sadak Yojana. That's all.
That's all.
Please issue notice returnable by 4 weeks. As Mr. will appear for all except the finance controller.
Except respondent number
3.
3 is by name.
ARRDA, except 3, no?
Yes, except 3.
Mr. G. Tarak, as Mr. G. Tarak, non-standing counsel RWD, enters appearance and accepts notice on behalf of respondent 1, 2, 3, 1, 2, 4, and 5. No formal notice be issued in respect of proceed above respondents. However, extra copies to so and so. Steps be taken for service of notice upon respondent number 3 by registered post as well as by usual process. List after returnable for 3 weeks, I said. 3 weeks.
4 weeks.
4 weeks, yeah.
In the meantime, that may be.
What? In the meantime?
It is absolutely illegal manner, absolutely without jurisdiction.
No, my lord, the guideline doesn't say that superintendent engineer is the PIU is the chairman of the tendering authority or the SE. It does not.
PIU is also the superintending engineer.
No, executive engineer is the PIU.
Expert, having considered the submissions of learned counsel to the parties and also considering and perusal of the guidelines dated 07/05/2013, prima facie, the orders and office memorandum appears to be not in accordance with the guidelines for evaluation. What is that called? Guidelines for?
Guidelines for PMGSY, ma'am. For
guidelines
for evaluation of bids and award of contract under PMGSY.
Guidelines for evaluation of bids and award of the contract under
PMGSY.
Pradhan Mantri Gram Sadak Yojana, till returnable date.
In case of other civil construction, it is always there with it.
Till
PIU.
returnable date. What I said? And the perusal visual, huh? In prima facie, it appears to be in accordance with the so and so, huh? Thus, till the returnable date, the respondent authorities are to adhere to the guidelines, so and so guidelines, huh? Guidelines, and allow the respective superintendent engineer in their jurisdiction to be to act in terms of the said guidelines.
My lord, guideline doesn't say that. It's only in case of other works.
We didn't say that.
This committee is only particularly for long span bridge only.
We're not saying that you should allow the petitioners. We said as per the guidelines, all to the respective SEs and the respective jurisdiction.
That is the prayer. Obliged.
Item number 2.
What is this, sir?
Yes, I am impugning, my lord, order. This is order 1/4/2020 passed by State Information Commission, my lord. Now what? Page numbers start from 61, my lord. 61, my lord. Start
61. Passed by the
State Information Commission, my lord.
what is the state information?
Arunachal Pradesh State Information Commission, my lord. This pertaining
What
to
is the decision? Facts emerging from the appeal and decision. Where's the final operative portion?
operative, my lord, find 68, my lord. Start from para 11, my lord. Now, before I find this order totally absurd, my lord.
This commission, this appeal no longer requires any further in this and absolutely it extends disposal of the order is above. He may prepare appeal before appropriate forum in terms of section 23.
Right.
What is section 23 says? There's an appeal provision.
No, my section 23 is not appeal provision, my lord. This is for proceeding. Now, what if in this case, my lord, I file after history provision, I go file the second appeal, my lord. In terms of during the
What is the under provision under section 23?
23, my lord, it proceeding
RTI Act.
RTI Act, my lord. RTI Act.
Tell us what is this provision? Appears to be there's an appeal provision.
No,
This is by State Information Commission, Commissioner.
No, 20. 23, my lord, I believe is authority to impose penal bar of jurisdiction, my lord. This is 23, my lord, yes. This is me prepare, my lord. Where is this is bar, my lord? 23, my lord.
If the appellant or the respondent PIO feels aggrieved, the order of this commission as above, he may prepare appeal before the approved forum in terms of section 23. What does it mean?
No, my lord, this is bar, my lord. This is bar, my lord, saying bar of jurisdiction of the court, my lord. No court shall entertain any suit, application, or other proceeding in respect of any order.
Section 23.
23, my lord.
Then why they said he may prepare appeal before the approved forum?
No, my lord. That's why, my lord, I say, my lord, I find this is absurd, totally absurd order, my lord. What happened in this case, my lord? There is a direction by commission itself to comply to punishment information, my lord. The private PI did not comply, my lord. Accordingly, I.
RTI Act.
63, my lord. After hearing both sides, my lord, accordingly, my lord, page 63, my lord, 63, my lord. Accordingly, this commission passed the following direction, my lord.
Where I said
63, my lord.
commission had passed the
Following that order was passed, my lord.
pass direction
My
to
lord.
furnish certain documents of the information to the petitioners list of on not being complied with, the petitioners have approached the commission again for
Not again, my lord. In the same, my lord, the case was not closed, my lord. Next day, it speaks, my lord, for compliance, my lord.
and what is to provide? Not before that. Petitioners list. No. You just petitioners, huh? However, by the impute order, the State Information Commissioner has failed to close the appeal by not exercising its statutory jurisdiction issue notice returnable by 4 weeks. MS K. Wang Learned State Council enters appearance and accepts notice on behalf of respondent number
1, 2, 4, and 5.
1, 2, 4, and 5. Therefore, no formal notice need be issued. However, no formal notice need be served. However, extra copies be sent to the council for the petitioners to take steps for service of notice upon respondent. Respondent number 3. List after 4 weeks.
But these documents may protect.
We don't know what documents.
The information sought by me. My lord will only information sought by will not be destroyed, my lord. Otherwise, my lord will see, my lord. Yes, or even after order.
Still returnable that the information sought by the petitioner shall not be destroyed.
Okay.
Item number 5.
Please, you know,
Yes.
my lord, this matter related to compassionate appointment, my lord.
Compassionate appointment?
Yes, my lord. And especially in the police department.
What happened?
My lord,
to those interviews? What about those selection process?
my lord, we are challenging that notice for the advertisement, and then the written examination, and then the physical test. We are challenging that, my lord, in this competition. Otherwise, as for there is a 2 scheme, my lord. 2001 MO, OM 2001 and 2022. Everything was completed. The post vacancy was arose in 2000 under the scheme of 2000 OM 2001. Formalities were completed till the scrutiny of the documents. They have shortlisted around 468 candidates. Committee was constituted. Committee scrutinized the documents and then shortlisted 468. And then before that, they also done the assessment verification of financial status and economic status. That was also done. But then suddenly, after finishing all this procedure, except that report is not there, that is verification, assessment and verification of economic status of each applicant. That report we are not able to enclose in this writ petition, but then everything will be, selection will be based on this economic status of the applicants. And for that, on the basis of that application, the committee has to see whether they are eligible or not. That is on the basis of the point, that's called merit point system.
That you have brought on record.
Basically, we have filed RTI saying that we should be provided that all the applicants of that point-based system that which has been submitted by respective place where the applicant's family was last serving. So that report we are not able to get from RTI. But then everything will be based on that merit point system. And as for the two OM, one is of 2001 and another is of 2022.
Which one we should consider?
So in my case, all the application, everything was processed as per 2001 OM.
2001.
One OM. But then when it was a
What is the difference in 2001 and 2022?
Yes, there's only the differences only in the relaxation, but then it has the better in 2022. In the both eligibility, in the case of eligibility, there is no provision for examination, written examination. There is no provision for any physical eligibility test.
Which department?
Is of the police department. Only the thing has to be done is that PST, that's called physical standard test. That has been followed.
This is this office memorandum in respect of police department, or it's for entire all the.
This is for entire ballot. They don't have a separate rules, separate policy, separate notification, or any separate government order or policy for the police department. Only what they are saying is that there is a recruitment rule.
What is the quota? What is the
only 5% has to
the candidates?
Now in our case.
Total candidates.
Total candidate, they have
applicants. I mean,
applicant ballot as per the after following all the procedures. Total applicant is 468. They have shortlisted. They have scrutinized all the documents.
Supposed to be filled up.
At present, it is 36 posts. 36 posts.
Then how it is to be? I mean,
so that's what my lord. That's what I was trying to submit, that it has to be based on the merit point system, the economic status of economic status. Yes, I will just and then that is one. Another is that on the basis of this economic merit point system has to be based, and then committee has to recommend. My lord, I will just come to the both of the two OM. My lord.
So, are you ready? It can be disposed of.
Yes. Yeah, we are ready, my lord. So I'll just come to two OM, my lord. That is relevant to OM. First, I will go to all OM, my lord, is in page 56. Page 56, my lord. Before that, I will come to the eligibility, my lord. I will just come to it. Yes, page 52, my lord, is all OM of 2001, my lord. You'll also may see section 5, eligibility. May I just read? A, the last one. Page 52.
52.
Yes, my lord. Last paragraph, last line. Clause 5, eligibility. May I just read that two line? Clause A and B.
This is of 2001.
2001, my lord.
Scheme for compensation upon the state government revised.
May I read the eligibility, my lord? 52, last clause 5. A, family is indigent and deserve immediate assistance for relief from the financial destitution. This is the only criteria, my lord. Second, B, application for compassionate appointment should be eligible, suitable for the post in all respects under the provisions of the relevant recruitment rules. My lord. This is also in the all OM. And then I will come to the procedure, my lord. How the procedure
should be eligible and suitable for all the under the provision relevant requirement. Yes.
So, yeah, and then now, my lord, I will come to page 53, procedure. I will just read the relevant sub-clause. There is a, I can read from this one, A, my lord, A, B, C, D, still better.
Why you said it's a this thing?
There's no, my lord.
This type copy.
Yes, my lord, this is type copy, my lord.
Then when you said that exempted from eligible of the following requirement, what does it mean?
Yes, my lord.
Recruitment, eligible selection. What is this? We will not
basically
not be able to make out.
Yes, my lord. In this, under this 2000 OAM, we have enclosed the earlier recruitment process, which they have already done. They only follow they have to do only PST, that's called physical eligibility test. That is one. Another is that first they have to see the economic status of each candidate. The committee has to shortlist who need to be considered first. Prioritize that candidate has to be shortlisted by the committee.
I'm asking when you have typed this, the OM, this is a type of copy, page 53.
Yes, my lord.
Compulsory appointment exempted from what is eligible of the following requirements. What does it mean?
Which
page 53. This is a type of copy.
Yes, my lord.
Page 53.
All right, my lord. Compassionate appointment are exempted from the following requirements. My lord, this is page. Just we'll go to the original paragraph page, my lord.
Have you annexed the fair copy, Mr. Tapin?
200.
Original copy.
2001.
OM of 2001.
Typing is company procedures. This is the exemption here.
Yes.
Page 53. Exemption, no. So,
Who are these private respondents?
Lordship,
private
respondent are the candidate who have duly participated in the PET, Lordship, and were shortlisted for written examination, Lordship. And we have also duly participated in the written examination. So, Lordship, we are waiting for the result and also praying for result to be declared, Lordship.
Okay. There's an interim order.
Interim order.
Saying what?
Saying Lordship, let the examination be held, Lordship, and the result has to be declared or we give permission from this court.
Why only 5, 6, 7, 8? Only 5, 6, 4 candidates appear.
Lordship, they file an application for impleadment.
4 of them.
Yes, Lordship.
Yes, brother.
What about the others? How many candidates have participated?
Lordship, 112 candidates participated in written examination.
For 36 posts.
36, 34. 36 posts, Lordship.
Okay. Are you sure that you will be selected?
No, Lordship, but as we have participated in written examination.
So why not all of you? Why only 4 persons?
Lordship, because
others are not interested.
No, they are interested, Lordship.
Have they been impleaded?
No, Lordship. Only 4 of them.
4 of them.
Yes, Lordship.
Are you ready?
Yes, Lordship.
Another Lordship, the petition number 1, 2, 3, Lordship. They have participated in the written
examination.
Yes, some of you have participated.
And all of them participated in the physical test and
except 1 to 3 lawsuits, all of them were disqualified in the physical test.
Okay.
Well, our challenge is that they cannot conduct the PET, physical eligibility test, because earlier
But you have participated.
we are compelled to participate, Mala, in some cases, Mala. We are no way, because when they are doing in other ways, then we have to, we have other ways.
You have challenged earlier, not now. What is that?
But then the procedure, Mala, but then procedure,
What is that case, Tapin?
This judgment is your law.
Huh?
But the procedure itself is illegal, Mala. In that case, whether if I participated, whether I'm stopped or that is another issue, Mala. When the procedure itself is illegal, because they cannot do the examination process for the completion under the completion appointment, Mala. So you'll also have to see is whether they can conduct the examination for the completion and appointment, Mala. That is another issue. And if I participate, if we are compelled to participate, then are we stopped to challenge this through the writ petition, Mala? When they are, the whole process is illegal. When the procedure doesn't provide for the written examination and interview, even for the PET, physical eligibility, and the post was created prior to.
Madan Lal. You have participated? They 1, 2, 3. They have participated written examination also.
Yes,
Yes, Lordship.
They qualified in the physical test and they participated in a written
written.
examination.
Rest they have not disqualified
They appeared in the physical test. They
are disqualified.
Issue
Even the notice lawsuit in terms of which this selection process.
Sir Mo, you are aware of Madan Lal?
Mala, I will place.
It has been reiterated.
But the issue here is,
as in today.
Issue here is when this procedure itself is illegal, whether I am stopped to challenge, Mala. That is my.
But you could have challenged it earlier. You have failed in.
Another judgment your lordship may also produce is that Rajkumar, it says that when the procedure itself is illegal, then the candidate cannot be, even if they participated also, they cannot be stopped to challenge that order, Mallard. When your lordship has to see is whether the procedure which they have adopted is correct or not. If it is correct, then we have no case. We cannot challenge that because we have participated. We were compelled to participate, Mallard.
See, there are only few posts.
Yes, Mallard.
Right.
Yes.
That to be under the police station, the police department. Right. And there are many candidates. 400. You are also saying there are around 400 candidates.
No, 400,
400 applicants and only 5%.
Mallard, thing is that, Mallard,
now how to appoint it?
Mallard, thing is, Mallard, I will just make it in brief.
How many petitions are there?
Here we are 68 petitions, Mallard.
Suppose assuming that if your appointment is made only on the
economic status,
and
then the merit point based system, Mallard.
Then what is the merit point?
Merit
what
point is
kind of merit?
Merit point system is, Mallard. They have to see how much is the family's income. That is one. Another is that whether they have a dependent who is earning or not. Third is,
I think they have therefore they have shortlisted.
No, they have no shortlisted. I want to submit that way. They have no shortlisted. They have shortlisted the list of the candidates as per the earlier notice that has ended to only the verification of the documents. After that, they were supposed to recommend and appoint, but they have stopped there. As per the earlier 2021, the notice for the applicant were invited, they participated, and it went up to 2024, my lord.
What's the bar conducting written and physical test?
My lord, thing is that, my lord, when the scheme itself doesn't provide for the written examination, my lord.
And under the compassionate appointment.
Yes.
it's not a kind of regular thing.
Yes, that's not a regular, my lord.
Therefore, you cannot claim as a matter of right.
Well, I'm not claiming a matter of right, but then when they have initiated for the compassionate appointment, then they have almost finishing stage for the appointment. Then only they issued another notice saying that we want to advertise it, we want to have written examination, we want to have a physical test. So that is we also challenging that before that. Now,
in which post you will be appointed?
Well, many are widows. They are eligible for constable, special constables, constables, and some are.
Constable, you need to have a physical test.
Yes, my lord. But my lord, 2000
certain kind of selection procedures.
Yes, my lord. As per 2000, we are not denying that one. As per
this is only for the candidates, the applicants who have applied for on compassionate appointment.
Yes, my lord.
Therefore, amongst these having a
no, but they have. But even to select among the candidates, also they should have listed the eligible candidates on the basis of the economic status, which they have not done. As per the advertise notice that last notice, my lord, I'll just take the last notice, my lord. May see that last notice is, my lord,
149.
149, my lord. 149, my lord, was issued on 6 June 2024. I will just take to that, may I read that one. As per that, my lord, they said that application was, may I just read that one? This is important, that clause.
You complete one by one. What is the requirement as per OM?
My requirement, my lord.
Procedure.
Yes.
Page 56.
Yes, my lord. I will take to that procedure, my lord, only, my lord. Page 56, my lord.
Should meet the members of family government. This is what you are seeking.
My lord, as per the OM 2000.
Close 12.
My lord, as per the OM 2000.
Before the company for decision, if the company recommends on the case, will refer to.
Yes, my lord. Page 56, my lord. Relevant is C and D, my lord. As per the 2001, my lord. I can read from the B, my lord. Welfare officer in each ministry and department official should meet the members of the family.
I've seen it.
Yes, my lord.
Then,
so now D is the important, my lord. D.
yes, I've seen it.
Recommendation of the committee should place before the competent authority for the. Yes, my lord.
I've seen it.
Yes, my lord. So this is the only they should have after the application is invited.
Consider in the light of instruction to stand by the Department of Personnel so and so. This is issued by whom? Department of Personnel. On the subject by committee of considering one chairman, 2 members in the rank.
This is issued by the Commissioner of P and R Personnel, my lord.
C has been the complied with.
Yes.
C has been followed. Clause 12C has been followed or what?
Yes, it has been followed, my lord. It has been followed, and they have went up to the scrutiny of the document level, my lord. I will just come to that. I will just can point out the notice.
Then what about 2002 or
2012, my lord. 2012, my lord, relevant.
22 or 12?
2022.
Where it is?
Yes, my lord. It is in page, my lord.
Consolidated. 23. Office member. Page 63.
My lord, new one is, my lord, page 64, my lord. It starts from page 63, yes. Page 63 is that the government is approving that this new OM will be applied, and it is starting from page 64, the new one, my lord. And the relevant portion is, my lord, is in page 67, my lord. 67 is eligibility, my lord. No, it is the same, my lord. All
procedure.
Yes, procedure, yes. Procedure, my lord, is in, my lord.
73. Page number 73.
Yes, procedure starts from page 73, and relevant will be this one recommendation, my lord, is 15. 15, my lord. 13 and 15. Page 73, my lord.
13? Procedure.
Yes, my lord. It's page 73. I'll just read the relevant procedures, my lord. is in page,
followed or what?
page 74, my lord. Page 74, may I read that one? 13, may I read 13? The result of each round of selection should be, this is the result, my lord. 9, my lord.
Difference.
No. Only differences, my lord. We have just sorted out the differences, my lord. Your lordship may see that differences. We have.
It's okay. You just tell me. You just tell. It's okay.
Yes, my lord. Yes, my lord. Just may I read that that we have made this one comparative, my lord. Just we'll check to page 3. Page 3, my lord. And all one is not much in detail. Page 2 is the all one, my lord. All one is not in detail, but then
more elaborate.
More elaborate in page 3, my lord. More elaborate, my lord. Just may I read, my lord. It's in clause 3. Welfare officer meet the deceased employee's family within 30 days and explain available benefits. If the family is financially weak, they should be informed about the compassionate appointment. Officer should also help family filling the application, complete formalities, explain eligible posts. Department will also verify application details. Family income, that is important, my lord. Family income and other relevant informations. And 5th, every valid application should get, my lord, this is very important, my lord, should get a unique registration number within 2 weeks, 2 to 3 weeks, and applicant should be informed through email or other communication methods. 6, department can create a point-based, this is, my lord, this is very important, my lord. Department can create a point-based merit system to make compassionate appointment selection fair, transparent, and objective.
Okay.
7.
Yes.
Yes, my lord.
Then.
So committee should be headed by 3 members, my lord. 3 members. One is should be a chairman, 2 members. So thing is that the new one is more elaborate, and new one also doesn't talk about the written examination and then the physical eligibility test, my lord. So only thing is that this procedure has to be followed. They have to have a the list of the applicants who have submitted from different districts. They have to see the economic status. They have to go through this, and then they have to make the merit point system. And then who are indigent should be given first priority. That recommendation has to go from the committee, my dear lordship, not through the written examination and not through the physical eligibility test. We are not saying that there should not be a physical standard test. Physical standard test is being followed as per the old one also, and even in new one also, it doesn't talk about that physical eligibility test. Only the government which they are following is only the PST. So in our case, PST, Malad, all the candidates, they're eligible, Malad. And then there are also relaxation, Malad. As per the scheme, there are also relaxation.
325 persons have been appointed.
Yeah, this is the earlier, Malad. Of 2001 OM, there was no written examination, there was no any eligibility test. On the basis of point-based system, they analyze it, and who are eligible, most indigent candidate, they were considered, my lord. So now the present post also was created in 2001 scheme, my lord, and then it was followed till 2000. And I will just come to that notice, my lord, how they followed and they reached up to the final stage. Then only they
stage.
Yes, my lord. Yes, I will just come to that, my lord.
They have followed, in fact.
They have followed the 2001 for this 35 posts, my lord. My lord, I will just take to the page 104. 104, my lord.
Okay.
So important 104, my lord, is annexure 4. It's a dated 4 February 2021. May I just read, my lord? This is for information to all concerned that Arunachal Pradesh Police Department is going to conduct a recruitment under competition ground, and the list of the candidates who have already applied has been uploaded in Arunachal website. Further, the department is intending to give another 15 days, such and such, to those candidates who have not yet submitted their application in prescribed format to this office. It is also to inform that after completion of the aforementioned period, the department will not enter any application. Now, after this 2104, I'll take to the 111, my lord. There's another notice on the basis of this application, my lord.
So how many candidates here?
My lord, here, my lord, as per the
257.
257, my lord, as per the uploaded, my lord. Then, my lord, 111, my lord. 111. May I just read? It was dated 11 February 2022. This is for the general information to the all candidates applied for the appointment under competition ground in the police department that there will be assessment. This is very important, my lord. Assessment and the verification of financial economic status of the applicant at their respective districts, my lord. Until where the applicant's deceased guardian last served before his or her death. Hence, all the applicants are directed to keep in touch with their respective districts and until where your deceased guardians last served before his or her death in further directions. So this is a very important document, has to come from the respective districts wherever the deceased person was serving the last posting, my lord. So now after this, my lord, there is a physical, after this financial assessment and verification of financial economic status, then they also issue a notice for PST, my lord. I'll just come to 112, my lord. That is called physical standard test, my lord. That is in page 113. No, sorry, 112. 112. Notice, my lord. This is to inform a general information to all applicants applied under competition ground in Arunachal Pradesh Police Department to appear before the committee in person or a police headquarters that is such and such on what for PST, my lord. Only the PST is that usually for the competition. That's called physical standard test and personal appearance under competition ground. Further, applicants are directed to produce all the original documents, successor certificate, death certificate, education qualification certificate, age proof certificate, and there's all documents, my lord. And date of report batch will be, my lord, that's important, but will be uploaded shortly to Arunachal Pradesh Police website now. Now, after this PST, now what happened in 2013, my lord, I will just come to
page 150.
Yes, my lord.
150.
150.
150.
Yes, 150, my lord. The respondents, one of the petitioners here is in this writ petition, respondent who implemented himself in the other respondent, he filed a writ petition, and then your honorable court was pleased to stay this examination process, earlier examination process, but then they withdraw it with a liberty, and then case was never filed again, my lord. So we want to show that the role of the respondents, how they played.
So recruitment was stayed.
Yes, recruitment was stayed, but then they withdraw it. And then now they implement themselves as one of the candidates that we have participated. That's my lord. Now, my lord, important, my lord, in 113, my lord. 113, may I just, there's a page.
So your matter is very simple.
Yes, my lord.
As per the office memorandum, as regards the scheme for compulsory appointment, doesn't require written examination,
yes, my lord.
Physical test.
Yes, my lord.
It's only based on the financial, what do you call it?
Financial merit point system. That has to be considered.
There is a procedure is provided. Yes, other than that, you cannot have for appointment of compulsory appointment, you could not have
written
or
and of physical eligibility test. Yes, my lord.
That's only your case.
Yeah, that's my case, my lord.
So yes.
Lawsuit in particular scheme lawsuit 2022.
What is this 30? IA is for what?
IA is for modifications of the interim order.
Okay.
That will be subject to outcome of.
Yes.
Lawsuit come to the page 67.
Of what?
The writ petition. This is the scheme of 2023. It's serial number 5. Lawsuit will find eligibility. here the 5B, what you say, applicant for should be eligible and suitable for the post in all respect under the provisions of relevant recruitment rules. Here, suitable for the post in all respect, eligible is the education qualification must have lawship. And since in police department lawship, apart from this, the armed personnel lawship, other posts are also there. LDC is there lawship, peon is there, MTS is there lawship. All those post lawship, physical test may not be required lawship. But this in present case lawship, this is meant for the constable lawship. And their physical test is very much necessary lawship, mandatory lawship. As per recruitment rule also, physical test is necessary lawship, mandatory lawship. And therefore, lawship, we have invoked this particular lawship.
Applicant for compulsory appraisal should be eligible and suitable for post in all
respect under the provisions of relevance.
So eligible to there may not be any problem, but suitability you want to
Physical
test.
test first.
You want to test the suitability.
Yes. One cannot be who is not suitable for lawship, the armed personnel lawship. He cannot be picked up for lawship. It's a mandatory lawship. And if
for other post, you are not conducting any examination.
this
Written
particular selection is for the police constable only.
What about the others?
Others lawship, the vacancies are not here lawship.
Even
And
if
here
there is a vacancy, then
the,
you will go for the recruitment. Recruitment process. You will go for written examination.
no, as per this lawship. Basically, lawship written statement.
No, applicant for compulsory should be eligible and suitable
Lawship.
in all respect under the provision of the rule.
And so far, my
It doesn't indicate that you should you should go for written examination.
lawship written is written lawship. The test is concerned lawship. I too personally lawship. I have doubt on this lawship. There cannot be a written examination. I just agree on that particular point lawship. But here the case is that lawship. Physical test is mandatory lawship.
Eligible, you can make out from as per the procedure. But suitability, you will have to test the physical because of the nature of the job.
Correctly.
Nature of the job of the post, which they are.
Lawship. I'm even judgments are here lawship on that in that aspect lawship. If lawship see the page 149 lawship. This is the earlier lawship, the selection process initiated lawship, but it was lawship cancelled.
149.
149.
Yes.
And the present selection process initiated by this notice process. Here lawship, the head constable, so and so. Here, as per existing, so here two things we have stated lawship. One is the physical test, and other one is the written test lawship. What we said is that past physical test will be conducted on this particular date lawship, and those who have qualified in the physical test, then written, they have to appear in the written examinations. Basing on this very lawship, notice lawship, they have participated in the physical test. And except for petition number 1 to 3 lawship, all of them lawship have been disqualified in the physical test lawship. For other post lawship,
they are not challenging that.
They have not challenging that. Now, after participations in terms of this lawship, even lawship, this particular notice was not challenged lawship, earlier lawship. When this it was already hard last week, 2 weeks back.
No, we have challenged physical.
2 weeks back lawship, this matter was heard by lawship justice Anjumani E. But we have pointed out this particular notice has not been challenged where written examination has been demanded lawsuit. Then they filed last week amendment application and this has been challenged. But
that has been allowed.
Amendment has been allowed. When we have pointed out lawsuit because law is there lawsuit. You have participated lawsuit. 2 things here lawsuit. After participation you can't lawsuit. And second is the lawsuit. Itself it was not challenged in the prior petition earlier. Only last week they filed one application for amendment, and by amendment this has been brought under challenge laws. So what I'm submitting is lawsuit. Let's keep aside the lawsuit written examination laws. But all the petitioner lawsuit, except for 1 to 3 lawsuit, They participated in the physical test, but they have been disqualified. And apart from that, out of 68 lawsuit, petitioner lawsuit, here requirement is class 10 pass lawsuit, 24 are class 8 pass lawsuit. As per this assessment lawsuit. Then lawsuit, just to make it short lawsuit, I would like to place some judgment lawsuit. The first one is lawsuit, the Allahabad High Court's judgment. That is lawsuit Anurag Yadav and others. I would like to take lawsuit to the paragraph 23 lawsuit. 23 and the second part lawsuit. In 23, second part lawsuit. The primary duty of, here the same issue lawsuit, the physical. The primary duty of police personnel is to maintain law and order, to ensure enforcement of
For sub-inspector.
lawsuit, and to catch the criminals and bring them before the court for their prosecutions and prosecution. The criminal use all kinds of weapons, means of fast transport, and other modern gadgets to achieve their objective. A policeman had to perform a very hard and strenuous duty to round the clock. In order to be a successful policeman, has to be well built and strong and must possess sound physics. He has not to perform his duties sitting in an office, working on a table, which requires less of physical exertions. The police commissions so and so and so and so and so, which consists of highly expensive so and so and so and so. Here, ultimately, it was dismissed lawsuit.
What do you want to show?
Here, lawsuit, physical case was lawsuit, question lawsuit. And the petition has been dismissed.
Then?
This is the lawsuit one judgment law. Then second lawsuit, finally take up the lawsuit for 2022, one SCC. That is state of UP and versus Prem Lata. 2022, one SCC.
Yes.
Here lawsuit kindly come to para 10.3. 10.3. In the present case, as observed here and above, initially the respondent applied for appointment on compassionate ground on the post of assistant operator in police radio department. The same was not accepted by the department and rightly not accepted on the ground that she was not fulfilling requisite eligibility criteria for the post of assistant operator. Thereafter, the respondent again applied for appointment on the compassionate ground on the post of workshop hand. The case of the respondent was considered. However, she failed in the physical test examination, which was required as per the relevant recruitment rules of so and so. Therefore, thereafter she was offered appointment on compassion ground as messenger, which was equivalent so and so. Here also as per recruitment rule lawsuit, she failed to qualify in the physical test lawsuit.
Then
lawsuit. Next is lawsuit
Gitarani
lawsuit. This Allahabad High Court reported in 2024 SCC.
Why Allahabad High Court?
Lawsuit The division bench. Can I say paragraph 19 and 20? The present matter relates to compassionate appointment in a discipline force, that is police force, and under the relevant provisions of law, no relaxation in physical again is accorded even to the direct recruiters. And even if they do not complete the race in a specific time, they are not selected. Hence, no relaxation is available or to be extended for the candidate seeking compassionate appointment, who even have a subsequent chance to claim the next lower post within the 3 months. In the present case, admittedly, the admit card was issued by the state appellant for physical test, which took place on this, and she had participated in physical examination without any objection, compulsion, or duress, and with her own consent and free will, which is crystal clear from the declarations form dated so and so, filled up by her. In such admission situation, in case she failed in the physical test, then under the competent appointment, she could not ask for second chance to undergo the physical efficiency test again, lawsuit.
He's not asking. What he's asking, you could not have, because the office by your policy does not permit. There's no question of conducting physical test or the written test.
Here, lawsuit, that's what I'm pointing out, lawsuit. As per recruitment rules, a physical test, lawsuit. Physical test is a mandatory, lawsuit. And as per this scheme also, lawsuit, suitability has to be lawsuit tested, lawsuit.
So what about the written?
Written lawsuit, written, their lawsuit. Therefore, in fact and circumstances.
Have you followed the procedure?
Fact and circumstances will present case lawsuit. Because if we decide it on technicality lawsuit.
No, have you followed the procedure laid down in the scheme?
Lawsuit, if I come to the scheme lawsuit, that strict sense lawsuit that
has not been followed.
But situation has changed now, lawsuit. All the petitioners participated lawsuit. And there's a lawsuit judgment of Honorable Supreme Court lawsuit. Because some lawsuit, some of their parents died long time back lawsuit. 10 years back, 20 years back, 5 years back lawsuit. Also, there's a delay because vacancies were not their lawsuit. So their case could not.
That you cannot take the way. You have considered the case. You have verified everything.
Lawsuit.
You just wanted to, appoint them.
No, what I'm trying to
by recourse to selection process to find out the suitability.
Yes, lawsuit.
I think it defeats the very purpose of your scheme. If you go for written and physical test, it defeats your own policy.
No, how constable police personnel can be appointed lawsuit? That's why this judgment all it says lawsuit. The physical test was
okay. Except let us assume that you require to test the suitability as per the recruitment rule. Physical test. Why the written examination?
Okay, that's why lawsuit. In the present, the case of the present, apex of the present case lawsuit, the situation has changed lawsuit. They have participated and they have been disqualified in the physical test lawsuit. After they have been disqualified in the physical test lawsuit. What is the case of the petitioners now?
3 of them are there.
3 of them, they participated in the written examination lawsuit. Now, he is questioning the same result of the same examination where they have participated lawsuit.
Okay. That's all.
That's all, lawsuit.
Yes, madam.
Lordship. My submission will only be based on physical test, Lordship.
Okay.
Because I'm not the conducting authority here, Lordship. I have just participated in the written examination and also in the physical test, Lordship.
You want that the result to be declared?
Yes, Lordship.
You don't want to argue on the merit?
Lordship.
Of the matter.
On merit, Lordship, I have no submission.
You have filed affidavit.
Yes, Lordship, I have filed the affidavit
Affidavit saying what?
saying that, Lordship,
Okay. Okay. I'll go through. That's all.
My lord, yes, my
Any
lord.
judgment?
Yes, any judgment, yes, my lord. We have some judgments, my lord.
Not some judgment, relevant judgment.
Relevant judgment, my lord.
What is that? Rajkumar Saktiraj.
Umesh Kumar Nagpal.
Rajkumar Saktiraj.
Yes, Sir Rajkumar Saktidas.
And
then Umesh Kumar.
then
Then my lord,
you note it down. Huh? Who has submitted?
I have extra copy, my lord, and just place the extra copy.
Umesh Kumar says what?
Umesh Kumar says, my lord, relevant, my lord, Umesh Kumar, my lord, in relevant, it says that.
Just compile it. Submitted by senior government advocate. And then.
In fact, what he cited is of the physical thesis of assistant inspector, because compassionate appointment is only for the C grade staffs and MTS only. So
no, this judgment it's also on compassionate ground.
I will just
UP.
But then, my lord, they should have separate rules and notifications. But in our case, there is no separate rules and notification. Only the scheme.
Says, the clause 5 says to be eligible and suitable.
Yes, my lord.
Under the rules.
Yes, my lord.
For appointment to the constitutional rule says that the physical test is required.
The physical test is required, my lord. That is called the physical.
How you will be assessed? It's okay. The other part, the procedure which they.
Physical standard test. That is, we are not disputing, my lord. We are challenging only that physical eligibility is because as per this, under this compassion.
You have to be eligible under the rules. The rule says what? Relevant rules.
Relevant rules says the qualification, my lord. Qualification is there. And then
eligible and suitability.
Suitability, my lord.
How you judge the suitability?
My lord, suitability, my lord.
Doesn't provide.
My lord, suitability, my lord. As per
the scheme doesn't provide.
Yes, but then, my lord, government has been following, my lord, even in 2001 under that scheme.
Okay, follow this followed. Now they have.
They have followed, and then only we are not saying that there should not be. There should be that's called physical standard test, my lord. That is the weight, height, and the chest and medical fitness. That is we are not disputing, my lord. But in case of that physical eligibility, when the widow is applying for the job and she is 45 years old, she cannot compete with the other. Maybe she is.
You are applying for the post of constable.
Yes, that's what, my lord. But then. First criteria is the indigent, my lord.
Apply for the post of constable.
For the first criteria.
Apply for the post of babysitter.
First port is indigent, my lord. And then physically, my lord, yes, no doubt. But then they cannot be asked.
Clause 5 says that suitably eligible, you must be eligible. Applicant must be eligible and suitable.
Yes.
Under the relevant recruitment.
Recruitment rule, my lord. So physical, they have been following, and we are not disputing that there should not be a physical standard test by that.
Had it been only eligible, one could have understood that. Example, the education qualification and other thing.
Yes, my lord.
But suitability, you'll have to be tested.
Suitability, my lord. Suitability, my lord, they have been
for the post of constable.
My lord, suitability, my lord, they have
all written test is all for the constable.
Yes.
For MTS.
No, for all they have done is for all the written examination, my lord.
Constable.
Even for constable also.
Not even for.
No, only for
this exam, written exam is for constable only.
Yes, constable and a constable driver, constable, and then head constable, my lord. There are 3 posts are there, my lord. And my lord, your lordship may also see in this.
Your documents has been verified.
Yes, my lord. That is a list which I wanted to show in that, my lord. My lord.
Bone of contention is since the policy doesn't provide for written test and physical test.
Yes, my lord.
You could not have resorted to.
Yes, my lord.
Recourse to that. Yes. This is what you're.
Yes, my lord. As per this.
When you say, that's what I'm saying, when your policy itself says that applicants should be eligible and suitable as per the relevant rules. Then
No, as for that, my lord, they have already shortlisted.
what rule says for constable? Have you annexed the rule?
Rules, lordship,
It's in IA. They have enclosed, my lord, the IA constable is able. My lord, I'll just take to 116, which they have shortlisted. In that short list, there is a qualification, and then when the applicant's family has died, that whole detail is in the 116. After this verification, they were supposed to go for the merit-based system, and then recommendation has to go, but then they didn't go that way. They issued the impugn order advertising for the written examination and physical test, my lord. So that is 116, my lord. 116, my lord, it starts from 115. There is a committee of the board proceeding. It consists of 8 persons, and they have scrutinized and then listed out. And then they have candidate total listed is 468. Now, after this, they were supposed to go for the merit point system, physical standard test, and then recommendation has to go. But then instead of doing, they issue the impugn order, that is 149, saying that there should be written examination and then physical test, my lord. And also, my lord, important thing is that in the head constable, when they are considered for the compulsory appointment, class 12 pass, the subject which they have mentioned, I want to mention the chemistry and the diploma in the electrical diploma. even that subject. Otherwise, as per their recruitment rule, it doesn't, this subject is not there. Only the English, general knowledge, and the legal and police manual, as per their recruitment rules, say that it has to be followed. But then here, completely different in the qualifications again.
So we'll say go for recruitment test, recruitment interview, written examination as per the rules to test the suitability.
No, written test, my lord, that is probably no, there is no provision, my lord.
So how you'll determine the suitability?
Otherwise, my lord, if written test is
How you test the suitability?
My lord, that is physical standard test has to be there, my lord. Physical standard test. And then education qualification.
Rule annex in page 68.
My lord, education qualification, my lord. What is one? Second is that physical standard test. Third is that economic condition on the basis of merit point system, which is recommended by from the respective districts where
what has been done and what has not been done.
My lord, as per the affidavit,
education qualification they have done.
They have verified, my lord. As per this 106, I wanted to show that 116.
Financial status?
That is silent, my lord.
And physical test?
Physical standard test, this is also silent, my lord.
No.
They have not brought out.
They have gone for.
No, that is.
You have been disqualified.
No, that
you have appeared.
No, that is after the new notice, my lord. Earlier notice, my lord. There is already a physical standard test, but then that result is not. They have not followed that one, my lord.
Which earlier one?
Earlier, my lord, they have culminated up to the document verification, my lord. My lord,
they have gone further.
Only, my lord, issue here is, my lord, only they have issued the last impugn order which we have challenged. My lord, that is page 149.
Okay.
On the basis of that, the impugn has come up. That is a physical test and then result, my lord. That we are challenging that should not have been that.
What result?
Result of the physical test, my lord. That also we have challenged, my lord. That we are saying that
you cannot challenge. Why you have participated?
My lord, thing is, my lord, we are compelled to participate in this, my lord. No way, my lord.
You have no bargaining power.
My lord, that is, my lord.
You instead of seeking appointment on compulsory ground, you don't have the bargaining power.
Yes, my lord. There's no way. That's what we have participated, my lord.
I told you had a dharna also. There was a protest.
I think that I'm not aware of that, but then maybe
off the record.
Off the record, my lord. Just I have placed. I think another judgment is of Rajkumar and others versus that which is that when the rule.
Rajkumar and Shakti Raj.
Yes,
versus
that.
cleaners.
Yes, my lord. So may I plead that, my lord,
Irrigation matter.
my prayer is that, my lord, the petitioners and the others, many are not here as a read petitioner. They may be allowed to.
Problem is that you have appeared.
My lord, we
And
have.
you are disqualified.
But then the whole the compassionate
We'll
scheme.
examine.
My lord, whole compassionate scheme will be defeated, my lord, if it is followed that way, my lord.
Because
Yes,
as more learned counsel for the petitioner, and also had Mr. S. Napid, learned senior government advocate for respondent number 126 124. You are 5 to 8.
Yes, Lord.
5, 6, 7, 8. MS Y Gao, learned counsel for respondent number 5 to 8.
Lordship, this if recruitment rule, also required it will be noted, Lordship. This page 68 and relevant is page 75, Lordship.
68 and 75. IA, in IA.
In IA.
Or your
because
affidavit.
this is compilation. My
IA.
My IA, Lordship. And this particular recruitment is compilations of ASI, SI, and constable. So therefore, relevant is page 75, Lordship.
Okay.
Here is for constable, civil, APPV, and BN, Lordship.
IA.
Page 75, Lordship. It starts from page 68, but relevant is page 75, Lordship. Page 75. At serial number 7, Lordship will find education.
It's for all civil.
Yes,
FPBN,
yes.
IIBN, all.
Yes.
No, the recruitment, the compulsory appointment is also 3 branches. 3 branches.
This is, yes, 3 branches also.
Physical efficiency test. This is what you have conducted.
Yes, Lordship. Yes, serial number 7, Lordship. Lordship will find educational and other qualifications required for direct recruitment, Lordship. Here, serial number 1 is education qualifications. 2 is physical standard, Lordship.
You said some of them they have not class 10 pass.
Yes, Lordship.
Some of them are not past class 10.
Yes, Lordship.
Yes.
Yes, my lord.
Eligible also, some of the petitioners not.
My lord, I will just point out my.
Here, Lordship, 2 part, Lordship. One is physical standard, Lordship. The second one is the physical efficiency test. That's event, 100 meters.
So he's saying that only physical standard is required, not the physical efficiency test.
Well,
that is what he is saying.
Lordship, these 2 parts are required, Lordship. And it's serial number 10, Lordship. The down below. Here is for the examinations. General English, general knowledge, elementary mathematics. This part may not be the Lordship, so for compassionate appointment. I agree on that, Lordship. But this serial number, column 7, Lordship. This test, Lordship, physical standard and the physical efficiency. These are, Lordship, to.
Yes.
Yes, my lord. My lord,
some of them are even not eligible.
My lord, we have filed the additional affidavit, my lord. And then out of 68, my lord, 38, around 38 documents which they could give to us, we have filed an additional affidavit, and all are 5 are eligible for the even for drivers, constable, and 35 are eligible for the constables, my lord. Not for the head constables, but they are eligible for the as per the education qualifications, my lord. We have filed an additional affidavit.
Class 10 pass.
10 pass, 12 pass. And some are BA also, my lord.
Out of 68.
Out of 68, my lord.
Only 35.
Only 38 the petitioners, they have
eligible.
Have
you marked that?
Yeah, we have.
Which petitioner number and which one?
I can give that. I can mark it, my lord.
No, that it may take another month.
I can just say, then, my lord, I will just point out, my lord. I will just point out. Petition number 1, petition number 7, 27.
You just give it.
Okay, I will give that. Ablash.
Okay, that's all.
Right.
We'll pass the order. Let's see.
And one more citation just I have placed lordship. Based on the context, he said lordship 2001 scheme will be applicable. But this selection process started after lordship. We have adopted 2022 lordship.
22.
And this is Krishna Kumar law, who says lordship, and the day of consideration lordship. The rule, prevailing rule will be applicable also.
Yes.
Item number 7.
Item 7. On appears for the petitioner on call, the list the matter after 4 weeks. In the meantime, the respondents may file their counter appeals.
Item number 9.
PDB is yet to be filed.
Yes. You're for?
I'm for the state RWD.
You want some time?
Yes.
And Mr.
Otherwise, the petitioner is ready.
Petitioner. Jed Manna.
Jed?
Manna. Manna.
Manna. Jed. Jed for what?
Jingfa.
Huh?
Jingfa.
Okay. Jed
Sorry,
counsel appearing for Mr. K. Taja, learned counsel for the petition.
My lord, the affidavit is filed.
It's been filed.
Yes.
Why this is listed here? Press steps.
To the private.
For the season, so number has not.
There is private respondent also.
You have not taken press steps. Mr. The learned counsel for the petitioners to take press steps for service of notice upon respondent number 9. Within 2 days, 2 working days.
Okay.
Take for respondent number 9, you have to take steps, huh?
Yes, sir.
Please tell her. Await service report in respect of respondent number 8. You filed the affidavit.
Yes,
Affidavit may file on behalf of respondent 1 to 4. Yes. Mr. G. Learned counsel. Standing counsel RWD is present and submits that is present, huh? It's okay.
Item number 12.
What is the matter about?
May I please, Your Honor? I am on behalf of the petitioner side. Your Honor, this is a matter for the retirement benefits, Your Honor. Regular pension and so many beneficials as per the after a regular pension, Your Honor. So, Your Honor, regarding this matter, there was some departmental inquiry and court of inquiry happened since for 2019, Your Honor. After the court of inquiry, my lord, which I enclose in page number 23, annexure.
Ready?
Yes, my lord.
If not ready, some other day.
Your Honor, I fully prepared, my lord, because since so many long days, this matter is only pending and pending.
Week. Next week, Monday.
My lord.
Or Wednesday.
Wednesday.
Wednesday. We'll take it up on Wednesday.
My lord.
No, Wednesday.
Wednesday is holiday, worship. 27 is holiday.
You'll have to find out. I think instead of 27, I think it may be on 28.
Yes, 28 is DV day.
Huh?
28 is a DV day.
No. This holiday of 27 may be shifted to 28.
28. Okay. We'll confirm, worship, after getting the confirmation.
Or 26.
Monday. Make it Monday.
25.
My lord, 26 is possible.
26 is a division bench.
Or 29.
29 will be not possible.
Then 1 June, my lord. But my lord, my humble request is this matter already repeatedly adjourned. Give me some specific earlier serial number so that not goes the very last, Your Honor. Because
No, this was listed today for item 12. Only hearing list. Special.
That's true.
Special for you.
My lord, my humble prayer is there, my lord, because the petitioner is very old age person. His wife also the
have
cancer
already
patient.
retired.
He is already here. So sometime, my
You have
lord.
been exonerated.
Yes, my lord.
You have been exonerated in the criminal case.
No, not at all. Already.
You have been exonerated from the criminal case.
Yes, sir.
Huh?
In this, already what are the criminal civil matter? Not any case proved in against me, my lord. I'm very clear. Thing is that, my lord, this matter goes so prolonged, Your Honor. So for these reasons, this matter only came and after they did one another. So if specific serial number is allowed, Your Honor, it's much better, my lord.
This serial number 12, only hearing.
Yes, my lord. Because of their age only. Suppose next time the matter is listed, somehow
We'll
news
take it
came.
up on Monday. Monday.
My lord, Monday already listed in some case. Tuesday possible, my lord.
Yes, same thing will happen. Tuesday, DB. Okay, listed on Tuesday.
Okay, Monday, my 25.
Huh?
25, my lord.
When I say the 25, you say 26. When I say 26, you say 20.
Okay, 25, my lord.
25. Make it 25. As agreed to by learned council, but we will list this matter on so and so. Monday.
Well.